1993, Leah bought 5 parcels of land from Melly for more than 3 million pesos. They entered into a contract to sell wherein Leah must pay 500,000 pesos upon signing of the agreement, and the rest of the purchase price shall be paid in 3 equal installments. However, Leah failed to pay the third and last installment on the date agreed upon. Almost more than 2 years after the date set installment, Leah tried to remit the amount to Melly, but Melly refused to accept the same and had instead sold the same parcels of land to Bartolome for more than 7 million pesos. Leah filed a case for specific performance against Melly so that the latter will be compelled to accept her payment and issued a deed of absolute sale in her favor. Leah invoked the same under the Maceda law. Does Leah have a right under the Maceda law? Leah cannot invoke the protection under the said law. Her offer of payment to Melly was made almost 2 years after the stipulated date of the third and last installment. This is clearly beyond the 60-day grace period that Section 4 of the Maceda law provides. Thus, Melly was well within her rights to sell the property to Bartolome. Furthermore, in a similar case decided by the Supreme Court, it was held that contracts are law between the parties and they are bound by its stipulations. It is clear that the parties intended their agreement to be a contract to sell, that Melly must retain ownership of the subject and does not have the obligation to execute a deed of absolute sale until Leah's payment of the full purchase price. If you have any legal concerns, please do not hesitate to email us at ptv4newscenter@gmail.com. This has been Attorney JJ Jimeno Atienza for the Rule of Law.